is Dominique Young with DYLPC with another vlog. I know it's been a while, however, here I am with some more information for you and your small business. So I have received some phone calls previously into my firm regarding the CTA, which is the Corporate Transparency Act. And so people were really concerned because there is a reporting requirement that has some hefty fees and even criminal punishment for failing to comply. However, so I'm going to discuss that today. So the CTA is essentially a reporting statute where if you are a business owner, meaning you're a shareholder or a partner or an LLC member, the statute required you to report the actual beneficial owners, is what the statute calls it, beneficial owners, to FinCEN, which is the Financial Crime Enforcement Network, so that they know who actually owns the business for whatever reason. So, and then also included in that was they wanted information. They would keep that information for 5 years after the business has dissolved or is terminated. And then the information is also accessible for inspection and disclosure to officers and employees of the Department of Treasury, basically the IRS, because the purpose is they wanted to prevent any more businesses with improper motives, basically is what they are trying to prevent or head off. So the penalty for failing to comply with the Corporate Transparency Act is $500 per day, which will not exceed $10,000, and or imprisonment of no more than 2 years. Now remember, this is a federal statute, so it would be federal time. Okay, so the CTA is housed within actually a military defense bill, and so you may not find it if you're not knowing what to look for. So along with this statute, there are military appropriations, a lot of other things. However, the Corporate Transparency Act is withheld inside of that actual bill that was enacted. So it was enacted January 1st, 2021, and the CTA portion of the act actually went into effect on January 1st, 2024. So that was at the beginning of this year. So if you're freaking out right now, stop. Don't do that, because this is what happened recently. So the following rule was implemented on September 29th, 2022. Went into effect January 1st, 2024. Well, 6 weeks after it was implemented, which was September 29th, 2024, an individual sued. Okay, so Isaac Winkles and the National Small Business United sued Janet Yellen in her capacity, in her federal capacity, the Department of the Treasury, and Himali Das in his official capacity. So they weren't suing them personally, they were just suing them in their capacity as the leader of their department or of their agency. And so they sued them because Mr. Winkles argued that the Corporate Transparency Act was a violation of his 1st, 4th, 5th, 9th, and 10th constitutional rights. So let's break that down. So the First Amendment gives you a lot. It gives you the freedom of speech, gives you the freedom of religion, the fact that the government cannot basically create a religion and force you to abide by that religion. It gives you the right to petition the government for redress, and it also gives you the right to peaceably assemble. So the actual final order for the case doesn't really state what their argument was in regards to the First Amendment. So based off of the argument and that order from the judge, I'm thinking it's going to be a violation of the freedom of speech, the violation of the right to peaceably assemble, because you are coming together as with other people to create a business. And so if you're not able to do that because you don't want to report your information to the Financial Crime Enforcement Network. And then there's also the right to petition the government for redress. So if you feel like there is something wrong in regards to that, you do have the constitutional right to do that. So they're basically arguing that the CTA would infringe upon those rights. Now, the Fourth Amendment gives you the right, prevents the government from unreasonable search and seizure. And this basically says that there has to be some reasonable suspicion for the government to search your property, to search your person. Normally, you see this in criminal law because it comes up a lot, and it is discussed a lot in criminal procedure and in constitutional law and law school, because that is a vital right for you as a citizen within the United States. No unreasonable search and seizure. So essentially what they are arguing is the fact that me as a small business owner having to report my personal information to a crime enforcement network would be an unreasonable search of my person and of my personality without any good reason for you to have that information, right? So that would be the violation of the Fourth Amendment. You forcing me to provide you with information, and you under the suspicion that I might be conducting a crime when all I'm doing is conducting a regular, valid business. So that would be the violation of the Fourth Amendment. The Fifth Amendment is the Due Process Amendment, and the Due Process Amendment basically says that I cannot be punished for a crime unless I have been adjudicated in a court of law that I have actually committed that crime. And that is prevalent in the fact that you would have to report your personal information to a crime enforcement network. Essentially, that is what they were arguing for the violation of the Fifth Amendment. Now, the Ninth Amendment is that your constitutional rights cannot be denied or disparaged. So the fact that they were arguing the First, Fourth, and Fifth Amendments being in violation of Mr. Winkle's constitutional rights, they're saying that the Ninth Amendment is being violated because you are preventing the ability for them to peaceably assemble or petition the government. You're taking away the protection for unreasonable search and seizures, and you are removing their any small business owners' ability for due process because of this law that is requiring me to report, basically. And then the 10th Amendment, the violation is saying that the powers not specifically delegated to Congress, which is like the legislative body that actually creates the laws and has those laws go into enactment, is retained to the states. And so the argument there is that, and this has been stated like in plenty of cases before, if it's not stated in the Constitution that Congress can do it, the states are over it, which is especially why your business is registered with the state and not with the federal government, because it came up a lot. There were people that wanted business registration to be a federal action, and Congress chose not to do it. They said, no, we want to leave it to the states. That is why when you register a business, you register it with the state Secretary of State. So if you are a business that wants to work with my firm, it has to be in Florida or Georgia, because that's where I am currently licensed. Hopefully more to come soon. So what they're saying is, by the fact that you are requiring a small business owner who already has to register with the state and provide their personal information then in order to even register that business, the fact that you are placing actions that are specifically delegated to the states and giving the federal government the power to actually regulate that, it would be a violation of the 10th Amendment. And there's plenty of case law and legislative history supporting the fact that Congress specifically did not want to take on the ownership or the task of regulating small businesses or regulating business, period. they specifically said, well, we'll just leave it to the states. And that is why when you register for a business, you are registered in that state. And if you want to conduct business in other states where you are actually taking money in that state and operating in that state, you would have to file, as a foreign business in that state. It gets a little trickier now with internet and e-commerce. However, for the most part, you register with the state because it is a state responsibility to regulate business. So that is what Mr. Winkles and the National Small Business United argued were the violations, and that was the basis of their suit against Janet Yellen, Department of Treasury, and Himamali Das. Right? So after the suit was filed, of course, you have to file the complaint, and then you go through some other tasks through civil procedure. And they came to the consensus that, we can probably resolve this under summary judgment. And summary judgment just means that you have no issue or fact to argue about in an actual trial because the facts or the law is speaking for itself. Therefore, there is no argument. Therefore, we're asking the court to rule in our favor. So what the plaintiffs did was they filed a motion for summary judgment. And what the defendants did was they filed actually a motion to dismiss, claiming that they did not have standing to actually bring the action in court. So this is actually what the court did. What the court said was they denied the motion to dismiss because they determined that Mr. Winkles did have standing. He is a small business owner in the state of Alabama. Therefore, because he would have that reporting requirement as a small business owner, and the fact that he would continue to open more businesses and would have to continue to report his personal identifying information to the Financial Crimes Enforcement Network, he did have standing because he had injury. Because the law was enacted, it was something we have to do, and if he did not do it, then he would be punished. So the fact that there was impending injury to Mr. Winkles, he did have standing. Now, the other issue was the National Small Business United, because it's actually a nonprofit organization out of Ohio. However, because Mr. Winkles was a member of that association, the association had standing as well, because it impacted the members of that association also, not the actual association, but the members that make up the association. So they had standing. So that was out. Now, what the court did actually was they granted the motion for summary judgment for the National Small Business United and Mr. Winkles, because what the court stated was the defendants could not justify that the CTA was an actual exercise of Congress's enumerated powers, right? So basically they went back to the 10th Amendment that stated that, the regulation of businesses is to the states. And if the purpose of the CTA is to continue to regulate businesses, then it did not belong with federal enforcement. It belonged to the states, essentially is what they said. So the Northern District of Alabama determined that the CTA is unconstitutional. So now, when you're freaking out in the beginning, just know that right now you do not have to report to the Financial Crimes Enforcement Network your small business being the beneficial owner, because as of right now, the CTA is considered unconstitutional by a court in the Northern District of Alabama. Now, is that going to be for forever? It may not. However, I do think that there was a strong argument for the plaintiffs in regards to the amendments that would actually be infringed upon should the CTA continue. So the defendants did file a notice of appeal. They filed a notice of appeal, I believe it was on March 11th, 2024. And so appeals take a while. It takes a while for, the transcript to be, for the file and for the transcript to be transferred to the 11th Circuit. And then even once it gets to the 11th Circuit, you still have to have time to draft the brief And then even after you've drafted the brief and submitted it to the panel, you still have to wait for the panel to get to it and make a decision. So as of right now, the CTA is not considered constitutional. Therefore, courts aren't going to enforce it. So you do not have to report to the Financial Crimes Enforcement Network based off the CTA, because the CTA is not constitutional. Is that going to be forever? We don't know. We have to wait and see what actually occurs in the 11th Circuit Court of Appeals with the actual appeal and what the defendants have determined went wrong, or what rights they feel deserve national or at least circuit-wide attention regarding the district court order. And even still after that, the plaintiffs can still appeal to the Supreme Court, because constitutional issues of a national importance would be the issue to submit to the Supreme Court, right? So it may be a while before we actually know whether or not it's going to get started up again, and whether or not it's going to continue. Because you also have to take into consideration that, this was a statute that was enacted by Congress. So what Congress could essentially do is, instead of continuing this in court, just redraft it and send it to be enacted in a different way, so that it has what is necessary in order to withstand constitutional muster. Basically, writing into the statute what is going to be necessary to meet constitutional requirements, so that there is not a violation of a citizen's constitutional rights. Okay, so the actual judge in the Northern District was Lyles C. Burke, and Lyles C. Burke is a University of Alabama alum. 2 times he did his bachelor's there, and he actually got his law degree from the University of Alabama as well. And the attorneys for the plaintiff side, one is a Harvard graduate and a UNC Chapel Hill Law School graduate. One is a graduate of the University of Tennessee and the University of Alabama Law School. One is also a University of North Carolina Chapel Hill graduate, an American University graduate, and a Wharton School at University of Pennsylvania graduate as well. And then the other attorney for the plaintiff, he is a Harvard alum 2 times. So I have read over the order, and I do think that they pose valid arguments for the manner in which the Corporate Transparency Act was actually drafted and enacted. So, and you also have to realize that, the state of Alabama produced Justice Hugo Black. And Justice Hugo Black was a staunch supporter for civil liberties and civil rights. He wrote the majority opinion in Brown versus the Board of Education, and then he also wrote the opinion for New York Times versus Sullivan, which stated that you have to have actual malice. There's an actual malice standard for defamation involving public figures. So, and then he was also one of the original drafters of what became the Fair Labor Standards Act. He originally stated that, the work week should be 30 hours a week. The actual Fair Labor Standards Act actually says now that, 40 hours is a regular work week. So I do think that the opinion, the way that it was drafted, I think it was drafted fairly. And I do think that I understand what the federal government was trying to do, because that can be an issue, trying to find out who is the actual owner of a business. However, that's the purpose of, you registering a business, not to make it difficult to find out who to sue, but so that you personally are separate from your business, because your business, if it is conducted correctly, will outlive you, and so, and your business may not always include you, happens plenty of times where you get fired from your own business. So a business is separate from the person, And so I do think that this opinion is something that was drafted well. And I do think that, in their appeal, there will be some things that will have to really and truthfully be addressed. Will this mean that Congress is not going to enact another statute that will actually satisfy what Judge Burke stated was lacking constitutionally? It doesn't stop them from doing that. It just would mean that it's going to take a little bit longer. So even though you're not required to report the beneficial owner's personal identifying information right now to the Financial Crimes Enforcement Network, it doesn't mean that later on down the line that there's not going to be some other reporting requirement that you will have for your small business. So for now, you don't have to worry about the CTA. Now, later, I'll let you know whether or not there's something else that you have to comply with. However, for now, you can just continue to file your annual registration every year with the state and make sure that you submit your withholding taxes to the IRS and Social Security. If you have any questions regarding this video or any other small business issues, you're more than welcome to contact my firm. You can call me at 866-823-9572. You can visit the firm's website at www.dominiqueyounglaw.com, and you can also email me at attorney@dominiqueyounglaw.com. Until next time.